So this is Steve, and we're here today with Judge Stanley Levine. He is in the Allen Civil Division court judge race. Stanley, we appreciate your time today.
Thank you. I appreciate the opportunity, Steve. I am the judge of the Allen Superior Court Civil Division. It's a position that I have held since January of 1999. I was reelected twice, once in 2002 and once in 2008. I'll tell you a little bit about myself. I have lived in Fort Wayne since I was 9 years old. Fort Wayne has changed a lot since then. I lived on East Fleming, which is 2 blocks from Pettit. Pettit was the south boundary of the city of Fort Wayne then. So that tells you a lot about the growth of the south side of Fort Wayne. I went to Harrison Hill. I went to Southside High School. I graduated in 1956. Went to Indiana University in Bloomington. Graduated in 1960. And then went to law school at what is now the Maurer School of Law. It was the Indiana University School of Law. Graduated in 1963, was admitted to the bar that year and practiced law here in Fort Wayne for 35 years. When I got out of law school, I was fortunate enough to find a spot in the Indiana Air National Guard, what we called Bear Field then. And the reason I got in was I was fortuitously ran into Ivan Lebmov, who was getting out. And so I spent, it was a 6-year enlistment, I think I spent 8 years. Had an interesting military career. I was started out as an airman. I was probably one of the oldest people in basic training at Lackland Air Force Base. And I was an honor graduate, which is a dubious distinction from clerk typist school. And I got to be the administrative assistant to General William Sefton, who was the wing commander, which was very interesting. Didn't have a lot of typing, but I had a lot of interesting things to do. You could get a lot done in the Air Guard if you said the general wants, and they did it. I then got commissioned as a second lieutenant, so I became from the oldest basic training to the oldest second lieutenant. I was the information officer, put out a base newspaper. That was my military journalism career. And I had the good fortune of getting recommissioned then as a captain in the legal office, where I had served as an administrative assistant, a clerk in the legal office. I have children and stepchildren from 2 prior marriages, 4 grandchildren. The newest one was just born in August. And I've lived here all my life and practiced law here all my life, since 1963. I had the good fortune in the 80s and part of the 90s of being the attorney or legal counsel to the City Council of Fort Wayne. It was an interesting job because you learn how laws are passed, and although I was the attorney for the entire council, also when a member of council wants to draft an ordinance, you kind of create a Chinese wall and nobody else knows about it, can't talk to the other members of council. So I had the opportunity not only to interact with councilmen, but to interact with my clients, with the mayor's office. I think we had a couple of different mayors while I was city council attorney. And that was a very interesting experience. I would like to tell you, if I can, since you asked how I became a judge, it's an interesting process. A lot of people don't know this. The Allen Superior Court was established in 1975, and it was established because the system that we had, the political system of selecting judges, was producing not a real good, I'll be on I won't be very tactful, I'll be honest and blunt, a lot of mediocre to poor judges. And it was because that they were unsuccessful attorneys in the most part, I have to say that. And they were, because we are in Allen County, primarily Republicans. That's not shaking a fist at the Republicans, it's the truth. So they started the Allen Superior Court in about 1970. And the way the statute was initially established, it would be a referendum vote. In other words, if we still had that system, it would, instead of what I'm in, the race I'm in now, it would be, should Judge Stanley Levine be retained? Well, there was a legislator who got crosswise with a judge and tried to bring it back into politics. And the result is that we have a nonpartisan race that I'm in. So because I'm in a nonpartisan race, I have backers who are both Democrats and Republicans. Should be no surprise to anybody that's how the system works. But I said I wanted to tell you how I became a judge. The statute provided a system of selecting judges in this fashion if there's a vacancy. They convene a local Allen County Judicial Nominating Commission. I'm not exactly sure. I think how it's. I think the governor appoints the citizen members, and the lawyers or somebody elects the lawyers. So there's 3 lawyers, 3 citizens, and at that point it was Justice Dixon who recently stepped down as Chief Justice, and there were, I think, 15 candidates, applicants, and I was selected as one of the 3 finalists, and then selected by the governor and fulfilled the term of the retired judge, and then ran at the end of his term, 2002 and 2008, unopposed. Why this is significant is I feel like I had to pass a test, so to speak, before I even could be appointed. And it's significant to me that we had a vacancy in our court in the civil division because Judge Heath transferred to the family division, and in the spring of 2013, last year, there was a vacancy, and I wanted to point out that neither of my opponents who say they want to be judge applied to go through that system. So I think, besides the fact that I am the incumbent, this distinguishes me from them. They didn't choose that path, and I'm proud of the fact that I'm obviously delighted that I was selected by the governor at that time, but I'm proud of the fact that I was vetted and they were not, and they didn't choose that path. Why? You'll have to ask them. Thank you.
So, Judge, why are you running for another term?
That's a good question. I have prided myself all my life to have been involved in public service at some point. Literally from the time I got out of law school, starting with the Air National Guard, my service as city council attorney. I was president of Legal Aid of Fort Wayne. I was president of the Allen County Bar Association. I've been elected by the judges around here to be a board member of the Indiana Judges Association, which is the quote small p political arm of the judges. I've served on community boards. I was president of the Fort Wayne Jewish Federation. I've had the pleasure and the honor to have been, and still am, on the board of St. Joe Hospital, where I serve now, and that's been my life. I don't know that I was ever told by my parents to put something back in the community where you live, but that's been something that I was trained and felt was my obligation to this community. So at the end of last year, sort of around the end of the summer, about this time or maybe early fall, I began to think, do I want to, been a judge, this is my 16th year, do you want to serve another 6 years? And frankly, I'm at the age where some people retire. A lot of my friends retired years ago, my contemporaries. And I decided that having been a lawyer, as I told you, I knew what bad judges were, and I know what good judges are. And some of the things that we have initiated, and I'll talk about that later, as a civil judge, I wanted to continue. And frankly, I tell this story. When we have jury trials, we have certain instructions that we give to the jury. And one of the instructions is, if there's a conflict of the evidence, you're supposed to resolve it first by accepting that each party is telling the truth. And if you can't reconcile the conflict, you are to do so by resorting to or relying on your wisdom and experience in everyday living. And I thought to myself, well, I have a lot of wisdom and experience in everyday living that I utilize every day to decide cases, to rule on motions, to rule on cases that are submitted to me. I enjoy the job. I think it's a rewarding job to be a member of the third branch of government, if you will. And my health is good. My father worked till he was 85. I'm not committing to doing that, but my mind works well, and I think I have had. I must say that in making this decision, it helps that I am a judge in the civil division, so I know what kind of cases I have. I'm never surprised when somebody sues somebody for a different reason, and there are many life situations there's many lawsuits, but I enjoy the job. It's a good job. I think had I stayed in the practice, who knows, I might be on the wrong side of the grass at Lindenwood right now, because I think I was ready for a change. But it's a challenge, and it's one that I wish to continue. And one of the benefits of being a judge in the Allen Superior Court Civil Division is, number one, I have excellent, hardworking colleagues in the Civil Division, and two, I must say that I have been blessed, if you will, that there are excellent lawyers who appear in front of me. A lot of them, most of them are from Fort Wayne, but we get them from all over the state, from Northwest Indiana, from Indianapolis, from Evansville, from Terre Haute. You pick a big metropolitan area, we get the lawyers. And it's gratifying to have a job where you deal with intelligent people who work hard and present their cases eloquently, well-written briefs, etc. And it's, you know, I can think of some other things that I could do over the next several years, but this is what I enjoy, and as long as I'm enjoying it, as long as I want to do it, I decided to run again.
Okay. Are there issues that are facing your division that are looming on the horizon? Not really. Issues. There's a. I think, if I may, I have to give you a little history so that you understand how the law has changed in my lifetime. When I started practicing in 1963, we didn't have a set of trial rules that were passed around 1970, about the time our court came into existence. And so when the trial rules came out, there were definite rules to guide lawyers on what they do, and the pleadings changed. My kid's great-grandfather, my two sons' great-grandfather, was a lawyer in Linton, Indiana, and when he died, as a sole practitioner, I
I took possession of a lot of his old law books, so they look nice in my law office because they're leather bound. He probably got them for $1.25 back in the days he practiced. But I pulled out the other day a book on civil procedure dated 1910 and realized that the same rules and pleadings outlined there they were still doing in the 60s when I became a lawyer. So a lot has changed. What happened was that the rules changed it so there's no surprises. In other words, the real trials, as opposed to what we see on TV, there's no surprise witnesses. You have to list all your witnesses. You have to reveal your exhibits. So that's changed. In my years on the bench, when I first became a judge in 1999, the civil judges got together and decided that we would change a few things. And one of the things that we realized was a lawyer would file a case and he'd have a hearing in front of Judge Boyer. I'm not singling her out, just to make the example. And Judge Boyer would rule on a motion and they didn't like it, so they'd go to Judge Levine and try to get another result later on in another motion. And we decided that for orderly business, it was important that each case be assigned. And Judge Boyer is the administrative judge. She would assign the cases to all the 4 judges of the civil division, and we did what we call a case management conference, and that goes out with the summons. That means that 90 days after the case is filed, the lawyers come in and we set deadlines for dispositive motions. They pick a mediator, and we set a pretrial conference. And that case remains with that judge. There's no judge shopping anymore. Mediation, of course, is a matter where it's submitted to an impartial mediator, and probably 80 to 90% of those cases are mediated successfully. The result is that we don't most cases we don't waive mediation. As a result, the pretrial conferences that we have are cases that they've mediated and they haven't been able to settle it. When I became a judge, I think there was about 2 to 3 year wait for trials. Now it's down to about a year. That helps. We also, I came up with this idea. I'm not taking credit. It was a collaborative effort, if you will, what we changed. We have what we call a status conference that happens 30 days before a trial. And at that point, we look at motions in limine to exclude evidence. We talk about potential instructions, any evidentiary problems that we have. And I came up with this idea when I talked to the lawyers. I say to them, all right, we're 30 days before trial. Is there a chance this case will settle? I know you mediated. And, that's where the rubber hits the road because they're spending a lot of money. And I came up with this idea, and it was accepted by my fellow judges, that we would do what we call judicial settlement conferences. That is, if I have a case that they say that they can settle, I give them a choice of Judge Boyer, Judge Avery, or Judge Bobet, and we have judicial settlement conference. And I'm proud to say, because I've done them for other judges, we probably have a 95% record of. The result is cases are resolved, which is, after all, what we're supposed to do anyhow. And I'm proud of that. And I'm going to get to your question about the issues, okay? But I'm getting it in a roundabout way to tell you how cases have evolved. Judge Bobet chaired a committee, and we worked with him on revising our civil rules for the Allen Superior Court and for Circuit Court. And he worked with Judge Phelps to do that and with our law clerks. And as a result, our civil rules were revised. Among the things that we changed were a couple. One, lawyers submit interrogatories. These are questions to be answered under oath. And the lawyers, we got feedback from the lawyers that the people have multiple, like hundreds of interrogatories, so we put a limit of 50, including sub-paragraphs. That will streamline the discovery process. We also have a general admonition to jurors not to do investigations of their own, and usually said something like using the internet and other. Now it's pretty specific. It says don't use the internet, Facebook, LinkedIn, Twitter, Instagram, things. Some of the things I admittedly don't use myself and don't know what they are. But it's a, let's put, if you will, a 21st century admonition. Now, issues facing the court last year, we went live on Odyssey, which is a statewide case management system, and our case management is kept by the state through their computers, and it's accessible to lawyers who want to know the status of the case. They can check Odyssey. The new thing that's on the horizon is something that the state is doing, and that's e-filing. It's already done in federal court. That means that they're putting out our request for proposal for providers, that a lawyer will be able to file his pleadings electronically. His or her, should be politically correct there, electronically, and they'll be available to us electronically. I see a day soon, because I mean you have no idea how many paper files there are and how many trees died for those paper files in a clerk's office. I see a day coming when I will have, instead of the monitor behind me, it could be on my desk, I'll have a monitor right in front of me, and I will scroll through the pleadings. I won't have to handle papers and flip through. When you have a big file, you're flipping through files this big. It's very, you know, I want to be part of that. It's not only have we changed our rules in 1970, but we have made that progress. And another thing that I see as my role is to keep, my role is not to let the lawyers run the case, but let the judge run the case. Sure, they'll do the work, but I have to, if you would, put the hoops up that they have to jump through. And I have been fortunate enough, by design, by luck or whatever, to have been on some panels in the state as well as nationally, not that I'm an expert, but on electronic discovery. And as you can well imagine, in our, again, in the 21st century, in the latter part of the 20th as well, when there are big cases, particularly in federal court, for example, if there is a say a discrimination case where somebody said they were not hired because there was discrimination because of their race or gender, there are discovery motions asking for all the emails that they've done for maybe 2-3 years back, maybe back farther than they even preserve them. So what happens is general counsel, the in-house counsel, has to establish preservation methods of preserving these things. And then there are battles in federal court, mostly, although I think there are judges that have had them here, about getting that electronic discovery, and it becomes a question of proportionality. In other words, what are you seeking and what is it going to cost to get? Because by the time you get some of those discovery requests, the method of even keeping the records has changed. The physical computers that you use are different. The different methods of preserving have changed. And so we have a cottage industry of experts that testify in those matters. My children are, frankly, were mystified that I would be on a panel like that, because they thought that I had not even completely adapted to or learned all the intricacies of a computer and internet and my cell phone. And I said, well, I learned, you know. So they were proud of their father who, you know, was doing, at least understood the method of doing that. It's going to happen in our court as well. And one of the things I discovered, I've been on these panels, and I haven't been an integral part of it, but I've chaired a couple of continuing legal education programs for our judges on the subject and brought in experts. And one of the things when I first got on there, they said, well, how is it different in state court, Judge Levine? And I said, well, in Indiana, at least, and this is what I represented at that time, that in federal court, I said we have a case management meeting, the first hearing, the first thing we do in a case. Federal court has that as well. And but they have what they call a meet and confer requirement, and that says that before they have that initial hearing, the lawyers have to meet and confer and discuss what evidentiary problems, what discovery problems, etc. In other words, they have to get together. And I always represented, at least initially, that we don't have that in Indiana. And it's true that in our initial hearing we don't. But then I was sitting one day and I was confronted with an evidentiary problem, and the lawyers were fighting about it. It was a big case and big battle. And I took a hard look at our trial rules. And the trial rule, lo and behold, not a revelation, maybe I should have done it sooner. It said that when you have a pretrial conference, there is a meet and confer requirement. Now, I told you, a pretrial conference happens, it's the second big hearing that we have. And so what I have done when we have these is I have a meet and confer. I order the lawyers, I set if we have a big battle, I set a preliminary pretrial conference on the very issue they're fighting about, and I make them meet and confer. Most of the time, those hearings go away. 2 days ago, I had 2 lawyers come in on a motion to compel discovery and a motion for sanctions, and it was apparent that they weren't playing hide the ball, but they weren't meeting. So there were 3 lawyers, 2 on one side and one another. I said, not going to have the hearing right now. Go down in the courtroom and try to resolve this. An hour and a half later, they resolved everything. I didn't have to have a hearing. That's what a judge is supposed to do. That's the challenge that if you're a good judge, this is what you have to do. I would like to tell you something that I learned early in life in my legal career and had to learn again. We used to have something called city court, and the judge at the time I became a lawyer was Joe Christoph, and there was a rite of passage for young lawyers that he would see on the street. Says, I want you to pro tem to act as sitting judge in city court tomorrow. And I'd say, never been a judge. And he said, you'll figure it out. So I'd been a lawyer for a few months. I knew what criminal law was. I knew what the standard was beyond a reasonable doubt. But that is where, that's one area where the rubber hits the road, as you say, and it's people's only contact made with the legal system. And you hear amazing, they're misdemeanors, traffic cases, drunk driving cases, assault and battery, things like that. And, quickly I learned you have to make a decision. And I enjoyed it. It was kind of a challenge the first 10 minutes, and then I got into it. And, we had that interesting custom. The old city court was where the history museum is now. And somebody filed a change of judge. The next lawyer that walked in the door literally became the special judge, and they'd go in another room and hear the case. And I revisited that, if you will, my first day in practice as a lawyer, as a judge. It was January 3rd, I think, 1999, and it was really snowing hard. We had a blizzard. So there I am, first day of work, there's a blizzard. And I hear on the radio, that on WOWO, that the courthouse is closed. So I'm thinking, so what? I'm going to work. So I drive down there and I find out that circuit court's closed, but the courthouse is open. And my office was being renovated. I had a small office next to small claims court. Small claims court was located on the ground floor of the courthouse then, and I assumed the bench and began hearing cases because the judge who was supposed to do it didn't show up. And the first 2 or 3 cases I had, I took under advisement. I wanted to think about what I would do, and then I began to think, these people don't want to wait a week for justice. They want it then. So I realized as I sat there, you got to make a decision. You're not a mediator. You're not trying to figure out what this person wants or that person. They didn't come for you to analyze what they want. They want a decision. So I began to make decisions, boom, 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 on the bench. And I reflected afterwards about this. When I was practicing law, I took a number of hours of mediation training. I was a trained mediator. I mediated a lot of cases. And in mediation, you try to find some common ground. They teach you how to look beyond what they're saying to what they really want. That isn't the same as deciding a case. That is in opposite of deciding a case. To be a judge, you have to make those decisions. You have to be able to listen to what people say, listen to what they want, and then decide who wins and who loses. It's not an easy thing to do. It was difficult when I first began to be a judge. It's difficult now sometimes because the kind of things that go before us are highly contested, and they're looking for me to make a decision. That's not something that I learned the first day I became a judge, although I told you the first day I learned I had to do it. But you develop an ability to make demands on lawyers to help you do that. How do you do that? Well, if you have a highly contested case involving a lot of money, I tell the lawyers I want what we call proposed findings of fact and conclusions of law. And if it's important enough for you to submit to me, and I'm not a shill for my court reporter, get a transcript. And you don't have to file that until you get the transcript, and I'll give you 60 days afterwards, so that when you file your proposed findings of fact and conclusions of law, you can make reference to the actual evidence in the transcript rather than what you remember or took notes on. It's very helpful to me. And also, side benefit, I get a copy of the transcript and I can look at it as well. The other thing I tell lawyers is, unless, and I call them in, I said, unless you're putting on a dog and pony show for your clients, I don't want to hear closing arguments. I want you to file a post-trial memorandum after you've read the transcript, after you've done your findings. And it can be argumentative. I expect it to be argumentative. I expect you to argue why I should rule for you. But it will be much more cohesive than something you came up for a 10-minute off the top of your head talk. I found that very helpful. The lawyers appreciate that. That's my style. I don't do things, people come in and say, well, Judge such and such did it this way. Thank you. That's not binding on me. I do it, I hate to sound like Frank Sinatra, but I do it my way. And it's gratifying to know that this is in a sense, although they're adversaries, when lawyers do that and submit it to a judge, it's a collaborative effort. They submit something to me, and of course I have to make the decision. It's a challenge, but it's one that I want to keep doing.
Earlier, several months ago, I received an email from the Daniel Borgman campaign.
Yes.
And he cited several different things that he wanted to work on if he were elected.
Sure.
And the first thing, and I'll let you comment on this, a domestic violence problem-solving court within the Allen Superior Court.
Well, I've seen the email. First of all, that's outside his purview. It's not something that the Civil Division would do. He would need the concurrence of, and he said this publicly, 8 other judges to get that done. He also doesn't mention that he'd need the concurrence of the prosecutor, who hasn't been approached at all on this issue. And if you note at the bottom of his email, he said none of this would cost Allen County any money. It's impossible for me to visualize that you could establish another court even if they wanted to and not have to have additional prosecutors and a judge to do that. So I think it's beyond the purview of what he could do. I mean, he could try it, but it's certainly not going to be done for nothing.
He also talked about establishing an evening court.
Okay, very interesting. Again, under the approach that Mr. Borgman says that it wouldn't cost Allen County any money, I would have to say this. We have a small claims court, and it's the highest volume small claims court in the state. They get 29,000 cases, new cases a year. We thought about doing a night court to decrease the volume and quickly discovered there's no way that you can do that economically, because you have to pay people from the clerk's office, you have to pay all the employees, the court reporters, perhaps the judges as well, overtime. So that is pie in the sky and impossible to do in any court without costing the taxpayers money. And we decided rather quickly when it came up years ago, impossible. So I would say that proposal is, wishful thinking, but to say that it can be done without costing the taxpayers money is absurd. It's inaccurate.
He also talks about modifying the existing workloads of unassigned cases by filling in where needed to help expedite the court's calendar.
Let me tell you something. Apparently, Mr. Borgman is unaware of how we do cases. I told you earlier that Judge Boyer was assigning cases, and we did have unassigned cases. She would not assign, for example, collection cases. Well, I told you also that we have Odyssey, which is the statewide case management system. All our cases, including those, are assigned automatically by Odyssey, by a computer. They're randomly assigned to the 4 civil judges. So Mr. Borgman is wrong. In his initial premise, there are no unassigned cases. So, again, he doesn't have the facts.
Can civil judges be involved in criminal cases?
No. Here. That was a quick no. All right. It was set up in our court. Originally, I think the judges did rotate, perhaps, but I know now we have 4 judges in the civil division. Each of the courts have magistrates as well. We have 3 judges in the criminal division, and there are magistrates there as well. I know that there are 2 magistrates in criminal division in the courthouse, and there's 2 magistrates in misdemeanor and traffic court over where the jail is in that building. We have in the civil division 3 magistrates that do nothing but small claims court. I have a magistrate who also does probate work, and I'm the probate judge. It's not advertised, but I am. So we don't venture into I don't do criminal cases, and thankfully, the family division has 2 judges and 4 magistrates, and I don't do, and I say thankfully because I did a lot of divorce cases, and I'm probably more qualified than anybody to be a judge in the family division. I chose to take a step in another direction, so we don't. Now, are there occasions when we venture into that? Yeah. One of the magistrates in small claim in family court didn't show up yesterday, and they were short a magistrate, and Charlie Pratt, the family judge, came up and wanted me to sit in. I couldn't do it. I would have. I have filled in family court on occasion. I had a policeman come in with a search warrant, and there were no criminal judges, and I signed the search warrant. I didn't know that I was supposed to keep a copy for Judge Gull, but I'd never done one before. Could I, if there were an emergency, if God forbid something happened to one of our judges and we had to keep the system going? Sure, I could. Do I want to? No. Am I qualified to do it? Probably not. I mean, I've never been a judge in the criminal. I wouldn't know the first thing about sentencing. I wouldn't want to do that, but I mean, on certain preliminary things like taking a plea where they have a script and you read things, yeah, God forbid something happened to one of the criminal judges, would I fill in? Sure. But generally speaking, no. And I would say conversely, the civil division, the criminal division and family division judges probably had, maybe except for Judge Heath, who was a civil division judge, probably don't have the remotest idea of what we do, nor would I want them to.
Can you give me a quick difference between what a magistrate is and a judge?
Yes. They have the same powers. A magistrate is appointed rather than elected or selected by the governor, if you will. The magistrates, I'll just tell you what I know about the civil division. We used to, when I first got there, we were approving everything that small claims magistrates did, and it was just tedious and time consuming. We decided not to do that. There have been times in probate part of our practice where I have signed off on what my magistrate Hauk has done, but we don't generally do that. But they conduct hearings. In the criminal division, they actually, over in misdemeanor traffic court, they conduct trials. They make decisions on who's guilty or not guilty. They sentence people. They know, and the magistrates in criminal division do the same thing over at the courthouse on felonies. Our civil the magistrates generally are, as I said, appointed. When we hired 2 new magistrates in small claims court, the 4 civil judges sat down and we interviewed them, and we appointed one. Judge Heath selected a new magistrate, Dan Pappas, I think last year, and it was an application process. Number of lawyers applied. Their pay is a little different. They're paid like 90% of what a judge gets, which is still a pretty substantial amount of money. And until about 2 years ago, their retirement system was different. Their retirement was under the Public Employees Retirement Fund, or PERF, and as of about 2 years ago, they switched into the judicial pension, the judge's pension, and they were able to, if they had money accumulated in PERF, buy years to go into their retirement. So they will retire in the same fashion that we do, so their financial position has been enhanced that way, and we have a very good retirement plan, and when you retire now, there's like 2 or 3 different retirements. One is the 1985 plan. That means everybody's been a judge since 1985, and we now, the retirees in that plan, that would be me when I retire, you get a COLA, cost of living. When the judges get a percentage raise, the retirees get a raise. It's a pretty nice thing for people that stay retired for a long time. I pray to God I retire at some point and live for a long time to enjoy our retirement benefits. But it's a very decent retirement. You vest after 12 years, which means I'm vested, and you vest at 50%, and each year you get an additional 1% that you're there. I don't even know what percentage I'm at now, but at 56% or something like that. 54%, I think. And the reason I know this is that you can only get 10% more. And I thought about this the other day. Let's change that. When I get reelected instead of if. When I get reelected, if I serve for 6 more years, I will have 22 years, and then at 22%, at 22 years you get 60% of your pension. There isn't going to be a 23rd year, folks. I mean, I would say comically that when I'm elected, I'll probably I'll only run one more time, but I'm not going to run one more time. So I will just coincidentally, not by any design, reach the maximum vesting. So any year after 22 years, and there are judges on the bench who get 24 years, you don't get any more pension. Obviously you get increases in salary, etc. So it has worked. I've been fortunate enough to have been a judge when we have gotten substantial adjustments to our salary. Because when I started out, I mean, I can't do it on a percentage mentally, but we've had a substantial increases, and we would fight with the legislators, state legislature, about giving us raises, or salary adjustments, as we euphemistically call them, but they're raises. And finally, I said I was involved in the Indiana Judges Association. We have lobbyists. It should be no surprise to the world that judges, like everybody else, has lobbyists. That's the world in which we live. And we finally were able to negotiate with the legislators 2 things. Well, actually one important thing, and that is that instead of quibbling about what kind of raise we get, what we have done, and it's by statute, when the highest paid state employee gets a raise, we get a raise. And we get the same raise. Each governor does it differently. The Governor Pence recently, for last year, gave a bonus that wasn't a raise. And Justice Dixon was then Chief Justice, negotiated something, so we got the bonus as well. Now, it didn't change our base pay, and therefore the retirees didn't get the benefit of that, but he negotiated that for us, so we're in a good position. The other thing, the legislators, I give them credit for these legislators who fought us tooth and nail on raising judges' pay, came up with after they did all that for us, they came up with a system where when we get a pay raise, the legislators get a pay raise. They don't have to raise themselves. There's an incentive for them to approve our pay raises because they get the same percentage. And none of them are in it for the huge salary, as you know. They get a relatively modest salary. They get a lot of expenses paid. But that's what's happened over the years, and I suspect that's the reason that you'll see people running for judge, because when I became a judge, I was 60 years old. And in order for me to have accumulated in retirement the amount that would throw off what my retirement would be if I quit today or I didn't win the election, I would have to have put away between, in the last 16 years, many millions of dollars. And God knows what would have happened to that in 2008. So it's fortunate. And that's the way it should be. I think, you know, I would honestly say that I know what lawyers make. And a good lawyer, and I was a good lawyer, makes more money than I'm making now. But we're not in it for the money. I mean, it's nice that we're paid well, and I'm happy that I'm paid well. And my lifestyle is a little better than it was when my salary was $45,000 less. So I've had probably maybe close to a 50%, maybe 45 to 50% increase over the last 16 years. You know, I benefited from that and I'm happy for it, but again, it's not what a good lawyer can make, but I think we should be paid fairly. I don't think we're not getting an outrageous sum of money, but you want to attract quality people who don't have to take such a drop in their income. I took a drop when I became a judge, but you want to attract good lawyers, female or male, who want to serve the community and don't have to be penalized. They don't have to scrape by. And look, be honest with you. I made close to $90,000 when I started. That's not a small sum of money. It's a large sum of money. But compared to what I was making, it was not. It's much, and I'm not gloating. There are people who make a lot less money than I do, but they don't have the education and experience, and you know, I wouldn't, and I don't begrudge anybody in a profession making as much money as they can, and I know what doctors make because I represented some doctors and doctors' wives in divorces, and that was years ago. God bless them. Let them make all they want, because when, God forbid, I have to have heart surgery or a knee replaced, or a back problem or something, I want somebody that knows what they're doing. I don't want somebody that, now it doesn't mean that if they get out of medical school they don't know what they're doing, because they're trained too. But I don't begrudge anybody in this world, whether they're doctors, whether they're in business. That's what America's about. If you have the ingenuity, make money. I don't begrudge it at all.
Well, unfortunately, we're out of time. We're right up against it. But we really appreciate your time today. And we've had a good time talking with you and learning a little bit more about the civil division than we knew before. And we wish you well in November, sir.
Thank you. And you know, I've enjoyed talking to you. I like to talk to civic groups. I like to talk to kids in school and tell them that life on the bench is not what they see on television. And I hope you learned something. I learned something about you, and I hope you've learned something as well. And I appreciate the opportunity to have this talk with you. And thank you very much for allowing me to do it.
Yes, sir. And best of luck in November.
Thank you very much.